Good evening, everyone. Is the state ready to proceed?
Yes, Your Honor.
Is the defendant ready to proceed?
Yes, Your Honor.
Sorry, it took me a little bit longer than anticipated, but there was a lot of information to consider. Let me just start by saying that as multiple people have observed, this is a particularly difficult case because there's really nothing that the court can do that's capable of fixing the harm that has been caused to the victims in this case. So that being said, I've got to start with the law. I'm bound by the law, and the law gives me a guideline for how to analyze an appropriate sentence in this case. So I want to start with the Camacho case. It's really the first thing I need to address is whether or not the court's going to depart from the minimum in this case, which is 222 months or approximately 18 and a half years in the Florida State Prison as a minimum. The Camacho case, as Mr. Fitzgibbons pointed out and argued, lays out really a three-factor test. Is there a valid legal basis for departure? Is there competent substantial evidence that the facts support an application? Or do the facts apply to the departure basis that is being asserted? To both of those questions, I answer those yes. There is a valid legal basis for departure, and there is competent substantial evidence that would support a departure. And really, I'd find that as to all of the departure bases argued, with the exception of the disparity argument. I'll just comment on that one for a moment. The defendant has argued that an available basis for departure is the disparity between the guidelines and the sentence that Mr. Barano got. I don't agree with that. I agree that disparity could potentially be an available legal basis for departure. But in this case, I don't think it applies because I do think that there are important substantive differences between the facts as applied to Mr. Barano and the facts as applied to Mr. Herron. The state's put those on the record. I won't elaborate on it too much other than to say I think that the difference, the age of majority for Mr. Herron is one of those. But mostly I just think that the facts are different as between those two defendants. And so I don't believe that the facts in this case support that as a departure basis because I believe that a disparity in sentence between Mr. Barano and Mr. Herron is appropriate in this case. That brings me to the third question of should essentially the third factor under the Camacho case is should the trial court depart? And the court in this case is going to decline to depart. So I'm answering that question in the negative. The trial court in this case is not going to depart. And I don't reach that decision lightly. When evaluating an appropriate sentence, I will start with Florida Statute 921.002. It was pointed out several times the primary purpose of the criminal punishment code in Florida is to punish. And I've got to take into account the severity of the primary offense and the circumstances surrounding the primary offense. When I take into account circumstances and severity, a lot of what I'm taking into account really when I sentence is intent and harm. And in this case, there wasn't any evidence, and nor does the court believe that there was any specific intent to do harm, in this case to the victims. But there was intent to drive at an egregious speed, 102 miles an hour, regardless of the consequences and regardless of of who that ended up harming. And then the second part of that, the second component, is the harm caused. And in this case, it's just impossible to have greater harm than the harm that occurred in this case, which was the loss of a mother, loss of a baby, and really the loss of a family as it existed when this occurred. I did consider, I also want to make a record, I did consider sentencing Mr. Herron as a youthful offender, but for the same reasons that I'm discussing, I didn't think sentencing him as a youthful offender was appropriate. I agree that youthful offender was something that the court could have done. I did consider it. I carefully considered it. But the court just found that due to the serious nature of these offenses, the extreme nature of the conduct, and again, the level of harm, that a youthful offender sentence was not appropriate. So given that the court is not departing, the guidelines call for a sentence of essentially 18 and a half years at a minimum, and 30 years as a maximum. And the court doesn't find that either the minimum or the maximum is appropriate in this case. I've said it several times, that serious nature of the offense, egregious nature of the conduct, and mostly the harm that's been caused prevent me from putting this as a bottom of the guidelines minimum case. But the departure bases argued by the defendant did provide some reason not to put it at the top of the maximum. And specifically, the court did take into account that the defendant's 18, certainly responsible for his actions, and he's being held accountable for his actions. But the age of 18, the court finds is a mitigating factor and shouldn't put this at a maximum. Also, the complete lack of prior criminal history is something that the court considered as preventing this from being at the top. So having said all that, the court is going really toward the middle between the minimum under the guidelines and the maximum punishment permitted under Florida state law. So on count one, vehicular homicide, the court's going to adjudicate the defendant guilty, sentence him to 9 years in the Florida State Prison. On count two, same charge, court will adjudicate the defendant guilty, sentence him to 15 years Florida State Prison, and that'll run consecutive to count one, for a total of 24 years Florida State Prison. Count three is a misdemeanor, unlawful racing on a highway, so the court will adjudicate the defendant guilty, sentence him to time served. Give credit for time served, I believe, 2 days. Court will impose mandatory court costs. Mr. Herron, you have given up the right to appeal the determination of your guilt or innocence. You do have 30 days to appeal the sentence of the court. And I'll direct the bailiffs to take Mr. Herron into custody.